A notary public is asked to notarize a power of attorney for an elderly client in New York State. What essential action must the notary take before notarizing the document? To answer this question, let's have a look at section 182.3 of the Notary Public License Law entitled Requirements for Notaries, and subsection A states, all notaries public who wish to perform notarial acts in New York State must, and we can jump to subsection 2 for the purpose of answering this question, obtain satisfactory evidence of the identity of any principal or other individual appearing before the notary in a manner authorized by this part. As well, we can jump to subsection B for the purpose of answering this question, in which it states, a notary may refuse to perform a notarial act if the notary public is not satisfied that 1. The principal is competent or has the capacity to execute a record, and or 2. The principal's signature is knowingly and voluntarily made. So with all this in mind, let's have a look at our 4 choices to determine our solution. Choice A states, confirm the identity of the signer and ensure they understand the document they are signing. Well, this aligns with what we just read from, because indeed, the notary public must obtain satisfactory evidence of the identity of the signer. And as we saw from subsection B, the notary may refuse to perform a notarial act if he or she is not satisfied as to the competency or whether or not the person signing is doing it knowingly and voluntarily, which is another way of saying that the person understands the document that they are signing. So therefore, choice A seems to be our solution, but let's have a look at choices B, C, and D just to be certain. Choice B states, administer an oath affirming that the signer is mentally competent. Well, that is not stated as a requirement in the law. There are cases where such an oath may be required to be administered by a medical professional or in the case of an attorney in certain circumstances, but for the purposes of notary publics and notarizing a document, that's not stated as a requirement here, and therefore choice B is not the correct solution. Choice C states, witness the signing of the power of attorney by at least 2 disinterested witnesses. This is not one of the requirements of a notary public. Indeed, there may be powers of attorney in which witnesses are required to sign, but it is not the notary public's role to witness the signing of disinterested witnesses, and therefore choice C is not the correct solution. And finally, choice D states, require the signer to sign the document in the presence of an attorney. There is no such requirement in the law, and therefore choice D is not the correct solution, which indeed leaves choice A, confirm the identity of the signer and ensure they understand the document they are signing, as the correct solution.